the property management industry, fair housing offenses are considered especially troubling. In the United States, a dedicated fair housing attorney, Leslie Tucker, provides case explanations and best practices. These are some cases.
Hello, everyone, and welcome to the Fair Housing Insiders Case Files, Episode 9 with Leslie Tucker, the principal at Williams, Edelstein & Tucker, and I'm your host, Jonathan Sarr. The case that we're talking about today highlights how not everything may go as planned when getting forms ready for a lease application. So, Leslie, can you share with us how one property's decision to not rent to a prospect because their doctor didn't return forms in time led them to legal action?
Absolutely. This is an interesting case, and it's really all about kind of procedure, your policies and procedures. The plaintiff in this case is an Army vet who had been prescribed an ESA, an emotional support animal, by his VA psychiatrist. The ESA that he ended up getting was a 70-pound Doberman Pinscher. When he went to apply for an apartment at the defendant's property, which, by the way, they had a policy that they had a weight restriction up to, I think, 25 pounds for pets. He included with his application a letter from his psychiatrist explaining that he is disabled, that he needs an emotional support animal in order to, mitigate his symptoms of his disability. The letter, however, was dated about 13 months prior to the application, so it was a little bit over a year old at the time. The staff at the property took the letter, but also had him fill out an authorization to send a verification form to his verifier, which is pretty common for a lot of housing providers. The verification form that this company happened to use asked really only two questions. Is the person disabled under the Fair Housing Act? And does the person require this animal in order to, reside at the property? So it's a pretty simple form. 6 days after sending the form to the verifier, the staff allegedly informed the plaintiff that they'd give it 3 more days, but then if they hadn't received the form back by then they would have to deny his request. Allegedly, and as alleged in the complaint, the plaintiff then called, his doctor's office and said, "Hey, I need this form done." And apparently his psychiatrist had been on vacation, wouldn't be back within those 3 days. And he knew that he would, basically not meet the deadline that had been given to him by his landlord. He, according to the complaint, withdrew his application since he knew he wouldn't be able to move in with his emotional support animal, and ended up filing a complaint with HUD. HUD found cause to believe that a violation had occurred, and then, of course, this lawsuit resulted. As all cases go, that is one side of the story. There's obviously more than one side of every story. And the housing provider in this case had multiple defenses to these allegations. One of them is that they say that in the 2020 HUD guidance on assistance animals, which many of you may be familiar with, it states that requests for assistance animals should be completed within 10 days. So that kind of justified the deadline that they were giving him. They felt like they needed to have this request, done, responded to, and completed within 10 days. They also allege that there's evidence that the plaintiff's medical situation and potentially need for the animal had changed since the original VA letter had been given to him over a year prior. And they also claim that the plaintiff was allegedly telling his verifier not to fill out the verification form. So there's a number of different sides to the story, obviously. This is for a trier of fact to decide, and this case still is ongoing. But it does bring up a number of really interesting issues procedurally.
Okay. There's a lot of details there. So that's, thank you so much for that explanation. So a couple of questions. I found it interesting, the 10-day item that you referenced there. So is it a legal requirement that a housing provider complete every assistance animal request within 10 days?
So I'm glad you asked. And the answer is no. This is not a legal requirement. And I've heard this from verifiers before. I've heard it from some of my clients before, that they believe that this 10 days is sort of a hard and fast rule that HUD has given to you, and it is not. That guidance does say, yes, it is a best practice to try to get these done within 10 days, but that is not a strict sort of deadline. There are a number of reasons that you may not be able to fulfill a request within 10 days. One of which is the verifier may be out of town. You may not be able to get that information back in 10 days, and that's okay. As long as you are doing your due diligence, you're following up, you're making sure you get that form out in time. So if you don't have everything you need within 10 days, you can't make the decision. You have to wait until you have all the information. And if the tenant does give you information and you need additional information, you need to give them time to get it back to you. What the guidance says is within a reasonable amount of time. There is no specific amount of time that you are required to give or you're required to take in order to give these responses. As long as it's timely, it's reasonable, and you are not kind of just letting things fall through the cracks.
Yeah. Okay, very good. Makes sense. So should the defendant in this case have required that the verification form be completed even though the plaintiff provided a letter from his doctor?
So I think that's going to be a major issue in how this case is decided, because it is a fact that you can't require verification be provided to you in a specific format. So you can't say, we will only accept this information on our verification form. If you receive a letter that has that exact same information on it and has all the information you need on it, you need to accept that letter as verification. And then sending out a subsequent form, even after you've received a valid letter, HUD considers that you requiring people to kind of jump through extra hoops that they shouldn't jump through. In this case, however, I think it's relevant that the letter was old. It was over a year old when he submitted it. And really, verification that's over a year old, you really have a right to get that information re-verified to make sure that the situation is the same, the needs are the same, the needs haven't changed within the last year. So I think in getting old verification, you do have a right to reach out and get kind of renewed confirmation that, the need is still there. So it, and I make a big deal of this because a lot of my clients do tend to do this, in that they have a process. Their process involves a verification form. So just be aware that while you can have that process and a form can be a part of it, if you get a letter, like they did in this case, the letter checks the boxes. It's timely. It's not old. It's from a reliable verifier. And it states, yes, this person has a disability. This is why they need this particular animal or whatever their accommodation is. Then your form really isn't necessary because you have all the information you need.
Got it. Okay, lots of details in this particular case. So thank you so much for your explanation. I know it benefited our audience a great deal. So thank you, everyone, for tuning in to the Fair Housing Insiders, Episode 9, Case Files. Take care, everyone. We'll see you again soon.